Uh, you've done an amazing job in winning a lot of cases in the lower courts, and very likely the administration is going to appeal a lot of these cases. And as they go up to the higher courts, and in particular to the U.S. Supreme Court, are you folks working together to try to figure out what sequence the cases should go up, which cases are most likely to be successful when you get there? Because, just as an example, the president fired the members of the Federal Trade Commission. That's a direct contradiction of 90 years of precedent. That would be a great case to get to be the one to debate the unitary executive. So I'm just curious as to how you handle all that.
Those firings are such a good example of how the coalition works together seamlessly. There's because there's more than any one organization can do alone, and we need to have four wonderful organizations like those you've chosen in order to be able to cover the landscape. And there are others as well that are very important. I will answer your question and use the exact example you gave me. The firing of the heads of independent multi-member agencies. Ever since FDR tried to fire Mr. Humphrey, the then head of the Federal Trade Commission, the case went up to the Supreme Court, and the Supreme Court held in a case called Humphrey's Executor, because Mr. Humphrey passed away and the executor of the estate wanted to collect the back pay. And the Supreme Court said what FDR did was wrong, that it's the prerogative of Congress to set up these multi-member bodies. Single-member federal agencies are a little different. We won't get into those. So Donald Trump has fired a series of these individuals, and you have different groups who have I'm representing one. The Merit Systems Protection Board has a lawyer counsel. They were fired. The National Labor Relations Board, the series of these agencies. My client is the head of the FLRA, the Federal Labor Relations Authority. She was fired. What was the excuse for firing her? Article 2. The president is saying that his powers under Article 2 of the Constitution are greater than Congress under Article 1. They said that this agency should have 3 members and that you can't just fire for any reason. You have to have a good reason. He offered none, just Article 2. He also thinks he's more powerful than Article 3, the courts. He thinks he's more powerful than federalism, what we call our federalism, which is the states and their power. So we went to court on behalf of our client. We won an injunction in the district court, federal court. She's back at work. That's something that had only happened once in federal history. And now we'll see which of these cases go to the Supreme Court. Now, Jeremy, here's the wrinkle. We don't get to pick and choose. We have our own. We talk to each other. We work together. We prepare together. But the Supreme Court is also controlled by which cases DOJ wants to appeal. So we don't know yet which of the cases is going to be first, but it doesn't matter. They're going to pick the weakest one, but we're going to do everything we can to get the strongest one there. So it's not totally in our control, but that's an example of how all the groups work together. I talk to Skye's colleagues every day. We're incessantly in touch, and Skye. Skye, we traded a bunch of texts today. We did not exchange any war plans, friends.
Everybody is focused on the Supreme Court. I think we'll say a few things to dovetail on Norm's conversation. I mean, one, I think you're seeing these cases are very coordinated and they're very strategically litigated for 60 days or 55, 60 days when you have over 130 cases. There's not that many that have gone up yet. And you have people filing and really making, I think, good strategic judgments about the pace of the cases to the extent that we can control it. We can't, as Norm said, control the pace the government wants to take it up. The second thing I'll say is that people are very focused, I think, on getting the strongest records possible. That's typically quite easy to do with this administration because they operate so outside the bounds of the law. I think there are opportunities there, even as the cases go up, because these are just so outside the bounds of the law. You're not going to be able to just make conclusions based on what you perceive a judge's ideological commitment is to how they're going to rule here, because the administration is operating in such a atypical and unlawful way. And the other thing I'll say is that the coordination and collaboration has just been really great. And I think there's a number of groups that are prepared to take cases all the way up to the court. Norm has one that's going up. There's other groups that kind of wait in the wings and maybe called in as things get more senior, as things get higher up in the appellate system. And so it's a real community that way. And we'll just have to continue to see sort of how DOJ takes these things up.
So I think of all the questions, the one repeated most often, which reflects, I think, a great deal of understandable anxiety on the part of many people on the call, is what is the plan if the administration just simply refuses to follow court orders?
First of all, let me say, in Trump 1.0 in the first administration, our experience was you could file a case, do some good communications, get the public focused on it, and it was an effective way of getting the administration to slow down or stop. In Trump 2.0, you've got to file your case, you've got to win your order, and then you have to be committed to ensuring that the government is going to comply with that order. Because if you're not vigilant about that, we are seeing that this administration is, whether they're keeping their lawyers in the dark or what, we'll get to the bottom of it, but they are, compliance with court orders has not been their number one priority. Let me just say that. In the early cases that we started seeing with our court orders, and I think in the AG saw and Norm saw, and I think in the early cases, and we're still seeing, whenever there's a question about compliance, the lawyers are immediately raising it. And the judges are being very loud, and they are saying very clearly, we expect these orders to be complied with. And then all of a sudden you see the administration come back in line. So that has been, and that's going to be part of the strategy, is being very vigilant. The courts will do their thing, and the forcing the administration to come back in line. That was kind of what I was saying until about a week and a half ago, when alongside the ACLU, we won this temporary restraining order on a Saturday with the wartime powers. The judge was very clear. Judge Boasberg was very clear about, he's issued the order. He wants it complied with immediately. And then you saw a number of U.S. officials, including our Secretary of State and high-level officials in the Justice Department and the White House, making statements that suggested they thought it was optional, that they had to comply with this judge's order, and they started attacking judges, and things have really ramped up. And so we, in our case right now, have a federal judge that is determined to get to the bottom of sort of what happened with compliance with his order. And our major takeaway is that all lawyers, even though this is not something that you do typically, all lawyers are going to have to really make sure that we're litigating those compliance issues. Now, of course, the courts have more power than I think a lot of people realize they do, in terms of holding people in contempt, in terms of imposing penalties. And so we think that you're going to see some of that start happening in these cases. And then fundamentally, the big question, I'll let Norm have the big resounding piece, fundamentally the big question of what happens if we just end up, and at the end of the day, the Supreme Court says something and the Trump administration just doesn't want to comply with it. We believe that is an area where both the American people, the courts, and Congress will have to do their part to hold the administration accountable, and that, the courts are doing a good job in checking this executive branch, but fundamentally it will need to be both other branches. But Norm will have a great answer to that kind of final question as well.
Before you start, I want to make sure we get to as many questions as we can. And I certainly understand that public opinion is a huge part of the strategy here, because with it we can do everything, and without it we can't do much, right? But so I think a lot of people are in the questions are concerned that public opinion is not moving in our direction, as evidenced by sort of the caving of big organizations like the law firms, the universities. So I'm curious as to what sort of leverage do you think that the administration has over these firms? Why it is that
Sure.
they're caving, and what can we do to as part of your litigation and public opinion strategy, to get people to see that if we don't fight now, we won't be able to win later?
The first guardrail, as you well know, the first guardrail is rule of law and the justice system. And in those almost 200 cases, Trump has been banging and banging into that guardrail. It's holding. Those loud collisions with the guardrail and judges standing their ground, that loud collision is waking up the second guardrail, which is the political class, the treetops, which in turn is rousing the third guardrail, the grassroots. I think I'm mixing my metaphors. Do you know there have been twice as many demonstrations? There's a political scientist, Erica Chenoweth, who covers them. We cover them on the Contrarian. We were the first publication in the country to have a beat for the democracy movement in the era of Trump. There have been twice as many demonstrations as in 2017. There's going to be big rally in DC and all over the country on April 5th. Judge Susan Crawford is leading Judge Schlemiel, her competitor in Wisconsin. I think you're going to see that's a test. That's become a referendum. The people v. Trump, they're calling it in. People v. Musk, they're calling it in Wisconsin. So we're seeing all of those being activated. Trump tried to do a flood the zone, but as Skye said, he was met with rule of law, shock and awe. And that is setting off these other effects. That's why the political, we believe, look at the AGs, how activated they have been. They just had a town hall together. Thousands of people came. The grass tops and the grassroots are getting motivated. What better example could there be than force multiplier?
When you do these lawsuits, do you work at all with the Democratic Party, or that's a whole separate thing?
No, we do. We're C3. All of the lawsuits we've brought have been C3. So
Ours too.
we don't. These are nonpartisan, and in fact, the support we provided in Skye's case, 24 conservatives. These are hardcore. My board has hardcore movement conservatives like Bill Kristol. I debated him over the Iraq War as part of my Obama campaign duties. Stephen Risher, the former Maricopa County recorder, you might have seen him testify to the January 6th committee. He's a libertarian. Bill Kristol says Risher makes him look like AOC. And we have Joe Walsh is on our board. He's the founder of the Freedom Caucus. So these are nonpartisan lawsuits that do have both sides of the political spectrum. I have another part of my life where I do politics, but these lawsuits are just down the middle, bipartisan rule of law, and we're winning.
So far, so good. We're proud of you.
0-2, but also the Supreme Court. You asked about that, Jeremy. Trump administration is 0-2 at the Supreme Court. John Roberts just publicly chastised Donald Trump. I don't think he's going to be voting for Trump in these cases. I had another case go up just yesterday. My employees, those 20,000 reinstated employees, my case out in California federal court. So I think Donald Trump is losing and he's lashing out. And I have hope for the Roberts Court.
You have to have hope for the Roberts Court. What else can you have if you don't have hope for that,
If
right?
the first guardrail fails, then you have the second guardrail, then you have the third guardrail. That's the genius of the founders and framers.
Right. So the birthright citizenship cases, were you working on those too? What's going on with those cases?
Those are dead losers at the court. Again, the coalition is all working together. Some of those cases are up there. I think those cases will lose potentially 7-2, 6-3. The Constitution is
The
very
government,
clear.
the Trump administration will lose, is what you're saying.
Yeah, the government, which has appealed them up to the Supreme Court, dead loser. Skye, do you feel differently?
No, I think there's votes for birthright citizenship, as we would hope. I think many people think that on the Impoundment Control Act, this is the notion of the president trying to not spend funds that Congress is setting has to spend, and to impound funds. I think many of good Supreme Court practitioners believe that there are 5 votes on the Supreme Court in favor of the Impoundment Control Act. The president wants it to be held unconstitutional. I think the litigators are being very careful about how they're moving those cases. But this is also where I'll just say, I think that the administration's strategy in these first 55 days to act like court orders are somewhat optional, that they may not have to follow them, to now be engaged in, deep attacks on lawyers and on judges. I don't think is a smart strategy for them, even on the merits in the Roberts courts. It's very hard, even though those are compliance issues, to divorce kind of how this administration's operating that way with their positions in these cases. And so I think that that's a fight that was not wise for them to pick.
So Arlene raised a question, which I think is of interest to all these groups. So you said you're 501c3. Are you concerned that the Trump administration is going to go after groups like yours to try to take away your tax exemption, things like that?
I think that all of us have a healthy degree of, reality, that this is an administration that has said that it wants to intimidate and that it wants to retaliate against people that are going to stand for the American people. And many of us have worked together in community to be prepared as possible for those types of attacks. And the commitment that I'll give you, and I know Norm will give you, is nothing is going to stop our work.
No.
But we are, and I will say, and it's one reason I think I'm really honored to get to be here tonight, we are having to dedicate organizational resources to physical and cybersecurity, to becoming prepared for what happens if we're unnecessarily targeted with tax exempt status. And so it's really just so wonderful that you all are supporting this work, because it is a different, there is more, there's just more expenses now associated with making those preparations than what you would have seen maybe 10 years ago.
Great.
Yeah, I'll just say that it's a sign, the kind of contemplating taking away tax exempt status is a sign that, it will be a sign that Trump is losing even worse. It will turn people against him even more. I don't think I have a single donor who won't say, fine, I'll give it to you in another vehicle, or take the risk. And to quote that noted tax scholar and legal philosopher Clint Eastwood, make my day. Donald Trump has taken away my security clearance now 3 times. He keeps announcing that he's doing it. Either he's senile and he just forgets and he does it all over again out of pique, or he takes it away and he turns it back on so he can say he's taking it away again. I'm fully expecting it to happen a 4th time next week. Is it like when you go to the coffee shop, the punch card, every 9 times your security clearance is removed, you get the 10th one free? It's just ridiculous. And I think we have to say the emperor has no clothes. The autocratic emperor has no clothes. So that's what part of the reason we started the Contrarian. My first hire after Jen Rubin was Andy Borowitz, the comic essayist. because
So-
we
so-
want to mock. We
Right.
mock. We do not, it's very serious. It's dangerous. It's perilous, but it's
So
ridiculous.
we're running out of time, but I think that two more things that I think people are eager to hear you comment about. One is the Paul Weiss versus Perkins Coie, the how the law firm is responding, and the other one is Trump's today executive order about elections, in which he's now saying that states are going to lose all their federal funds unless they require proof of citizenship at polling places in order to get people
What,
to vote.
why don't I do the Paul Weiss and turn it over to Norm to continue to talk about that, and then Norm can close it out on the election executive order. Does that make sense? First of all, I think we should not bury the lead with any of these executive orders or with any of these statements. The administration, and I think this is like important for people to understand, the administration is attacking lawyers and judges because they are losing in court and because the legal strategy is a huge guardrail and front line. And I think we have to just continue to remember that as we move forward. It is disappointing to see that a number of institutions, and it's not just law firms, it is also, as you mentioned, universities and others are not sort of rising up in this moment in the way that we need them to. But I will tell you, I think that there's a long road ahead. And that history is showing, and people are showing that they're expecting more. Norm and I are both collaborating with a range of our conservative friends as well as our more progressive friends on a letter that should be, I don't know when it's going to drop. It should drop tonight or in the morning. That is resounding about the importance across ideological lines of defending the rule of law and of speaking out against these attacks. It's a letter directly to Pam Bondi, asking her to as the nation's highest ranking lawyer, to do what she should do to defend the profession. And then we saw the state AGs today, the law school deans today, the ABA and local bar associations today come out. So we need to get some of our friends on the courage train here. And I think all of us are committed to doing that. But I do want to be, we are very inspired by a lot of the solidarity that we are seeing from lawyers across the political spectrum. And we'll send it to you guys when that letter drops, because there's a lot of folks, including a lot of conservatives, that are on here standing right there with us to say this has got to stop. Norm, I'll turn it to you for
Find that
law
already.
firms and election.
Guy's colleague Megan just sent me a little note with an update on that wonderful letter.
Oh, good.
She,
Good.
She put together with the conservative group, Skye and Democracy Forward, and Megan put together with the conservative group, the Society for the Rule of Law Institute, George Conway's group.
Norm, you give us a quick answer on the elections, and then I'll turn it back over to Evan.
So the elections EO is grossly illegal. We're drafting litigation papers. All of the civil rights and the elections groups, we're all talking to each other about how we're going to respond to it. And it's a good example of how, going back to the chart that I foisted on all of you, we were ready, we sprung into action, we have these relationships, we all talk to each other, and figuring out together what to do with that heinous, it's the latest act of election denial. It trashes Article 1, federal statutes, it trashes federalism. Constitution gives the responsibility for running, principal responsibility for elections to the states. And it's going to meet the same fate as all of these other losses that Trump has enjoyed in court. And I've enjoyed, with Skye and colleagues, doling them out. We're going to keep it up. Thanks to you.